Hello, everyone. Good to see you once again. So this is lecture. If you're going by the syllabus, this is actually the third lecture. Posted July 1st. This is chapter one. So we're finally in the book. Chapter one, an introduction to criminal procedure. Um, Once again, as I stated before, we're using as a textbook Criminal Procedure by Matthew Lipman. That's Lippman. Matthew Lipman. Um, Criminal Procedure, actually the third edition. And I usually lecture from the first edition. I just like the way it is. It's organized and it has the concepts and core concepts and summary statements before each chapter. It's kind of an outline of the chapter, so it keeps me on track when I'm lecturing. But of course, it does correlate to the other two editions. So the latest edition, probably the best edition, is the third edition. Um, so I would definitely recommend you get that book. It's actually supposed to be required. But of course, I have no means of checking whether or not you have the book. So I just hope you guys will will do the right thing and get the book. But it is fine if you have the first or second edition of the book. Um, just so you have something, so you'll be able to follow me. And I did cross reference the newer edition to make sure that they align with the first edition. So okay. So we're delving into chapter one. Before I even get into chapter one, let me see here. The Just so you'll be able to use the online resources for the book. Um, Let me give you the website for the book. It is www.sagepub.com slash LIPPMANCP. So essentially what that is www.sagepub.com backslash Lippman CP, which means Lippman Criminal Procedure. Um, so if you go to that website, of course, you can actually go to, of course, you would have, as a student, you would click the student portal. So click on the student tab. It has resources for every chapter. You can go to from chapter 1 all the way through 15. It actually gives you outlines of the chapter. So let's say even if you don't have the textbook, you should. But even if you don't have a textbook, what you can do, I just gave you the key to kind of having the textbook. Because what you can do, you can go to each chapter. There's an outline for every chapter, kind of like the core concepts that they have and summary statements that they have for every chapter in the book. That kind of gives you an outline of what the chapter is talking about and what you're really supposed to take from that chapter, kind of in a nutshell. You can print those out for 15 chapters and kind of be on pace with us as with me as I talk. Also, um, you can also choose to do there's like a quiz or review for every chapter that you can click on. There's like 10 or 15 questions that you can do for every chapter. I'm going to give you a little bit of a hint. That is, I like using those questions on my multiple choice exams, those exact questions. Now, I won't tell you which questions I'm going to use because my midterm is cumulative. So the midterm will be chapters 1 through 8. So, and the final will be chapters 1 through 15. So it's all cumulative. So you need to make sure that it would be a good idea to do all those multiple questions and make good use of the online supplements and the website that will allow. If I can almost guarantee that you're going to see those questions. I'm not going to tell you which ones, but you'll see those questions. So if you've done every question, and you can actually see what you got wrong, what you got right, what the right answer is. So you can actually get in there and do the questions, see if you're on pace. And this is chapter by chapter. So if I teach chapter 1 today, um, go through, follow through the outline and then do some review questions to see if you get it. Do the review questions, If you get them right, remember that right answer. I'm not even saying you can't print it out. You know what I mean? Just do what you do. But know the right answer for all those questions. If you do that for every chapter 1 through 15, now that's a lot of questions. You're talking about at least 10 questions per chapter. So that would be at least 150 questions, but some chapters have 15 questions. So that's a lot of questions. So you're approaching like 200 questions, 175 to 200 questions. But yeah, I think it's still worth it. So that will give you an opportunity to see all the questions that I'm going to use. I'm not going to give you every question, or I'm not going to tell you the exact questions, but you'll have access to all the questions I'm going to use. So if you've done every chapter, done the quest for every chapter, you should be more than prepared for my multiple choice midterm and final. So I'm just giving you that right now. So I don't try to hide the ball. I want you guys to do some work outside of class. That's why I give you this stuff. I want you to at least commit some time outside of class to do some work. And if you do that minimal requirement, you'll be fine. So, sorry, I digress, and I'll see if you can read. I don't know where is that. That right there is the website right there. That is the website. But I did give it to you. So yes. Now let's get back to the topic at hand, and this is chapter 1, which is an introduction to criminal procedure. So as a basic introduction, it's the book's introduction. There are good personal and professional reasons to study criminal procedure. Of course, for you guys are criminal justice majors, so it's a good idea to study criminal procedure. We'd be terrible professors and preparers for adulting life if we didn't, as criminal justice professors, we didn't offer criminal procedure. And no matter what you're going to do in your career, whether some of you guys may not even work in the criminal justice field, but if you are going to work in the criminal justice field, if you're going to go to law school, be a lawyer, some people want to go in law enforcement or probation. Others may work for clerks' offices and do stuff like that. But it's good to know what the criminal procedure process is. So I'm gonna put my spin on things, and I'm gonna kind of go by the outline of the book, but I'm gonna also inject a little bit of my DNA, my professional DNA, into the lecture. So, criminal law and criminal procedure, two different things. We'll talk about the difference. Criminal procedure influences the enforcement of criminal law. So that the definition of the book, that their explanation kind of I guess they assume you already know what criminal law is. So let me tell you what criminal law is. Criminal law is essentially the rules that govern us as a society. Um, Criminal law is nothing more than the contract between all of us as individuals and what would I say, as trying to think of a good word for it. Now, not just individuals, but as citizens. So, as citizens, if we're going to exist in this society, criminal law is what governs. I'm sorry, our relationship with each other. It's like so that's why in criminal law, if someone is accused of violating criminal law, they're charged, they're arrested, or they're given a citation. And the caption for the case is always the people versus or the state versus. So when you're brought up on criminal charges, you're coming before the people. Um, so it's like a solemn, trial or a solemn pronouncement of what you're accused of, and you have to face the people because when you violate a criminal law, what you've done is you violated that contract between you and everyone else in society. So these are the rules. This is how we in this country in America. The rule is we drive on the right side of the road. Everyone knows that. These are stop signs. These are the signs. This is the speed limit sign. What that means is if you violate the speed limit, if it says 35 and you're going 50, that means what you've done is you violated a code of conduct or that contract between you and everyone else who may be on the road. That means you're out of pocket, and what you're doing is not safe, and now you're a threat to everyone else who has to share the road with you. So that's kind of an example of how criminal law is that contract between you and everyone else. So that's why when you violate criminal law, you go before the people. So in North Carolina, we call it the state of North Carolina versus whoever the defendant is. In California, they say the people versus. So what's that mean? So essentially, it's not just the government, but the government represents us as people, as citizens as a whole. So that's what that means. As a matter of fact, the lawmakers that codify law, they're elected by us. So they're elected by us to make laws for us that govern how we're supposed to act. So it's like the code of conduct for how you as an individual act, and it's the contract between you and society. Now that's criminal law. So now that I've given you that definition, now you can better understand the book's explanation of criminal procedure. The books, read it again. Criminal procedure influences the enforcement of criminal law. So criminal law itself is what I just said. It's the rules that govern us as individuals in society, what we can and cannot do to each other, um, and what we can and cannot do to everybody. When we violate a certain law, we've now violated that contract between us and everybody. Now, who enforces? And now that we have these rules of law, who enforces the rules of law? We have law enforcement officers. Their job is to just that, enforce the law. This law, these codes of conduct have to be enforced. So when they're enforced, there now have to be rules that govern how it's enforced. So once the law is enforced, let's say you are charged or accused of violating the law by law enforcement, there are rules that govern how law enforcement have to act, how they conduct themselves, how they investigate whether or not there has been a violation of the code of conduct. Then, if you are going to be brought before the people as the defendant that's accused of violating this code of conduct, what are the rules that apply to how the system treats you? And when we say system, we're talking about the judiciary. So it's law. It's you as an individual and how law enforcement, how the judiciary, and when I say judiciary, it's not just judges. That's the system itself. So you're talking about everyone in court personnel, like your defense attorney. There are rules that govern how your defense attorney is supposed to treat you. Of course, you're entitled to effective assistance of counsel. We'll get to that in later chapters. Also, how the district attorney or the solicitor, for lack of, well, that is kind of the word they use in certain places, but the person that's charged with, I guess, trying or being the attorney that represents the state against you, um, in this action against you. So there are also rules that govern how the DA is supposed to act or the prosecutor. So you always hear me say DA. Some people call him it is prosecutor, but here in this jurisdiction in North Carolina, we always say DA, district attorney. So the kind of district attorney is the elected official, and they deputize, they hire and deputize people to work under them as assistant district attorneys or like their staff. So same thing goes with the public defender as well. You have a public defender that's an elected official. Then you have people that are hired and deputized under that public defender. Actually, same thing with the judges. So judges are all elected, but you have essentially the chief judge, and this is North Carolina state law, right? So if you're from somewhere else, this may not apply, but I'm just teaching you anyway. You always have the chief district court judge, because in North Carolina state court we have two levels of trial court. We have district court and we have superior court. District court is where we primarily handle misdemeanors, and on the civil side we handle small claims, civil cases and other stuff, child support, there's divorces, family and stuff like that. Then you have superior court, which, like once again, both criminal and civil. But in superior court, they have jurisdiction over misdemeanors and felonies. So if a case is indicted, we'll get to that later. We'll talk about the indictment process later. But it goes up to superior court, and superior court has original jurisdiction over felonies, indicted felonies. And then, of course, on the civil side, they have jurisdiction over larger claims, larger civil claims. So that's what it is. So you have judiciary on both sides of that. You have a chief district court judge who's elected. Now they hire staff, but they don't hire. They don't have the power to deputize and put people in judicial positions under them. Like, so, every judge is elected in North Carolina in the state court system, and so they're either appointed if there's a vacancy, or they're elected. And even if they're appointed, at some point in time, they're going to have to go back on a ballot at the end of a term to be reelected if they want to stay there. So there's no deputizing on the in the judiciary. So there's either you're elected as a deputy under the chief, or you're elected as the chief. So either way it goes, you're elected. Um, but that's how it's set up. Same thing with Superior Court. So um, it's a whole body of people. I always call criminal when I talk about criminal procedure. We're talking about the machine. So I know everyone has seen that, and probably in every criminal justice school, law school, there's always that what they had. It's almost like a flow chart, and this is the one for our book. There's a flow chart um, that shows the process. So once you've been arrested, or even before you're arrested, when the investigation goes on, that first you have the crime that's committed or alleged to have been committed. So you go from there. Then what's the next phase? Then you have the reporting of the crime. You have the investigation of the crime. Then you start to enter the system. If a person is charged, that person individually enters the system. When I say the system, it's a machine, and this does this not look like a machine of some sort, right? So once a person enters a machine, of course, the machine has different cogs and gears that help it run. It has a conveyor belt that takes the person through, and then there's certain sensors that say when a person's supposed to go out and when the person's supposed to stay in and go further. So it's almost like a factory. Now, and that's why I call the criminal justice system a machine. So of course there are rules that govern. There are different rules that apply and attach when you're in certain parts of the machine. So the deeper you get into the machine, the different types of rules are going to start to apply. There's some rules that just always apply. There's some rules that just apply just in the investigatory part, and there are other parts that apply maybe just here. Um, so criminal procedure talks about all the rules that govern the machine. And the machine, the gears and the cogs on the machine are people in the system. So everyone from the clerk of court to the DA to the bailiffs that help maintain peace within the courtroom and within the courthouse. Like I said, law enforcement officers, DAs, investigators, all these people are parts of the system. I myself, as a defense attorney, even though I work for myself, I am still a part of the system. When people hire me, they hire me to go in and I guess what's a good word for it? I don't want to say manipulate because that sounds a little negative, but I'm there to help push my client through the system and get the most advantageous outcome and get my client out of the system in one of those exits, get them out of the system in the most advantageous manner available. So either that's not guilty, or a situation with my client that there may be some guilt, some fault there, but we still want to get them the best situation at sentencing. So the system starts with the investigation and ends with sentencing and possibly appeals after sentencing. So it's a long process. So we're going to walk through the process this semester. Um, so that's what criminal procedure is. I call criminal procedure the machine, the rules that govern the machine. So the machine is the people. What runs the machine is the people in different positions. And namely, we're talking about law enforcement because that's how you get into the machine. And also, the different ways of getting the machine. You don't have to get into the machine through law enforcement. In certain states like North Carolina, a person can actually file a private warrant. I can actually charge as a citizen. I can charge you with the crime. I can go to the magistrate. Well, I can't charge you, but I can accuse you of a crime. I can go to the magistrate's office and accuse you of a crime. Give them your name. Tell them what you did. They hear it. Tell them what you're accused of doing. They hear it, and they say, "Well, that sounds like assault." So if someone smacks me in the face, I can go. I can run down to the magistrate's office and say, "Hey, so and so smacked me in the face. It was on this date. It was here at this place. I know them personally. This is their name and address. This is how they can be contacted and found." And the magistrate listens to me, and the magistrate says, "Okay, well, we're going to charge them with assault. You'll be informed when they're arrested, and whenever the court date is set. And at that point, a warrant goes out, either a warrant or a criminal summons." Um, so at that point, that person now has a charge. Now, that's the scary thing about that is you can be charged with the crime and not have committed the crime. So it's very, very easy. The system is accessible. It's actually easy to mess someone's life up. So I could go, I know I'm giving this this lecture right now. I can go and blame anyone that's watching this lecture, anyone in my class, because I know your name. I can go to the master's office right now and say, "Hey, that person smacked me on July 1st, and we didn't even come into contact with each other on July 1st. You saw me in a in a video lecture on YouTube, but still, I can go in there and lie, and next thing you know, you're chilling and enjoying life, but you have a charge hanging over your head and you don't know about it. So the only way you know about it is if it's a summons, you'll get something in the mail, and that's if your address even matches the address I give them, or the address is on your ID. Then, or you might have a warrant where where you're driving. Let's say you might run a stop sign and the cop pulls you over, like, "Hey, yeah, here's your ticket for running the stops." They ask for your license registration. They do that for a purpose because they're going back to that car and they have to do a warrant check to make sure that you're not wanted anywhere. So they do that warrant check. They will just stop you for your for running the stop sign. But now it's like they're gonna give you that stop sign ticket, and it's like, "Sorry, sir, but you have a warrant for your arrest. We have to take you in." So now you've been majorly inconvenienced, and it was because boys decided to lie on you. You weren't even around me, and you didn't do it. And I see that all the time in the system. So that's the crazy thing about the criminal justice system. Um, it's not just impropriety of the judiciary or law enforcement. It can be impropriety of people that have access to putting you into the machine. Like literally, it's not just law enforcement that can put you, that can throw you into on the conveyor belt. It's other citizens that are not deputized law enforcement officers, are not cops, are not sheriffs. These are people that have access to the magistrate's office. Like we can all do that. You as a citizen, not even a citizen, you as just a person in North Carolina, at least for right now, in Guilford County, or any county in North Carolina, you have the right to go down to the magistrate and say, "Hey, this person committed a crime against me," and they're literally they don't have any evidence either way, so it's one sided. They're just going to listen to you. We call it ex parte when it's one sided. So it's ex parte. They just listen to you. You're sworn. You put your hand on the Bible and you swear, and you can be telling a total lie. And even when you lie, a lot in most jurisdictions, there's no means of really punishing you. No one cares about punishing you for lying and putting this person in the system. There's some judges who see that and say, "Nah, you lie. You are obviously lying, and we see that you're bull crapping. So yeah, we're gonna hold you in contempt of court. You got to pay a fine, or sometimes they put people in jail for that. But for the most part, no one really enforces that rule that you have to tell the truth. So there are people in the court system all the time. It's crazy how easy it is for your life to change. And we'll talk about how when you get charged with the crime, even if the crime is dismissed, it's on your record. Like in the way American society is set up, you are a piece of paper, from the time you're born. When you get a birth certificate, you get a social security number, everything that happens in the system, even with credit reporting, but definitely in the criminal justice system, if something happens, now your name, your birth, your social security number, all that stuff, you're charged with that crime. So now when you're going to get a job years later, that they're pulling up. They're of course they're doing a background check. Cause people want to hire people that are trustworthy. And they want to check to make sure you don't have a record. So when they're hiring or in the hiring process, now they're checking your record and they see, oh, this person was charged with assault back in 2019. It was dismissed, but still is there. So now you have to be expunged and not expunged. Now this is something that can affect whether you make money or not, whether you get hired. So the stuff is real important. So that is the criminal procedure. That's kind of, I know it's a long explanation, but I wanted to tell you kind of I want to make sure you know the difference between criminal, what we call substantive criminal law, which is the substance, what defines what is and what isn't, and what we as individuals can and can't do, and then procedural, which is criminal procedure law, which is how the system works, how our interaction with law enforcement and the people in that system or in the machine. So the two things we always balance in the criminal justice system is security versus rights. In other words, um, our personal freedoms or our rights, our ability to walk down the street and not be bothered by law enforcement versus law enforcement's ability to catch the bad guys. Because no matter what anyone says about cops or whatever, there are bad people out here who are not cops. Like there are bad regular people out here who will kill you, who will steal from you, who will break in your house. And we're always balancing. We're in everything we talk about. We're always balancing the cops' ability to catch those real bad, the bad guys, versus your ability to not be mistaken for one and be able to chill and be who you are without being stopped and interrupted by law enforcement. So it's always a balance in security. Security being safe and not being affected by the bad guys versus your rights to not be bothered by law enforcement. So criminal procedure strikes a balance between the interest in investigating and detecting crime and in convicting criminals on the one hand, and on the other hand, the interest in protecting the right of individuals to be free from intrusions into their privacy and liberty on the other hand. So there's two things we're talking about. We're talking about we want law enforcement to be able to detect who the bad people are who are doing bad things and victimizing people. So that's one thing we want law enforcement to do that, but we have to balance that interest with the other interest of us people who are minding our own business, but we don't want our house to be spied on. We don't want the cops to be able to run up in our crib, right? So there's always that balance between security and individual rights and interests. So that's what we're always talking about. And in a lot of these court cases, we talk when we talk about certain rights and a certain in the court interpreting the Constitution. As we'll talk about the Constitution a little bit and the amendments. The court is always having to balance those two things. Like the cops got to be able to do something to catch bad guys, but how far are we going to let them go to catch a bad guy? We're going to let them go so far that they're able to intrude upon good people and bad people. Because honestly, we're kind of all bad if you think about it. Because uh, a person violates a law of some sort every day. The way America's set up, there's so many laws on the books that is almost literally your existence is almost illegal. If you gotta think a speed limit is just that's a speed limit. Most people say, "Oh, the speed limit is 35, but I was going 40. I'm good." No, the minute you go 36 miles per hour, technically you are in violation of the law. So people violate laws every day. So literally, there's a reason for each and every one of us to be pulled over, given a ticket, and taken before the state of North Carolina or the people every day. Like most people probably violate 10 laws, whether it be an infraction or a serious law or a misdemeanor somewhere in the middle. We all violate laws every day. So so there's some people that are worse than others that really violate. They don't just violate laws; they violate people and violating those laws. And then you have people like us that are just doing regular stuff, and we inadvertently violated the law. So we had to strike that balance between the cops catching bad guys and then the cops just how far they can go in doing that. Because if they go too far, now they can intrude on us and they can almost do what they want to do. I'm just gonna come in your house because I'm the police, and we have to stop that. So we have to strike that balance. Objectives of criminal procedure. Criminal procedure seeks to achieve a number of important objectives. These goals include accuracy, efficiency, public respect, fairness, equality, effective legal representation, popular participation, and allowance for appeal. So that's a lot. That's saying a lot. These are all part of the overall goal, which is justice. So justice, these are all what would I say? Elements of justice. So justice is all this word that kind of doesn't have a definition, but it does. But there are a lot of variables that go into determining what justice is. Um, so we're talking about accuracy. Of course, we have rules that apply. That's why we have burdens of proof, and we'll talk about burdens of proof. So in criminal law, the burden of proof is beyond a reasonable doubt. We'll get into that further, but the reason we have burdens of proof and we have stuff like that is we want to make sure that when the criminal justice system makes a decision, it makes it based on a very high standard. So we'll know that, hey, the person is bringing this case or saying that this person committed this crime. They have a very high burden to prove it. They have to jump a high hurdle. So that means if this person is found guilty, it's accurate. So we put very trying and tough burdens of proof in the criminal justice system so that will ensure more accuracy. So we got accuracy, efficiency, essentially how fast and how we're able to move, how fast we're able to move people through the system. That's why you have like speedy trials and stuff like that. We want to make sure that we don't kind of have someone stuck kind of for perpetuity in the system. Like cases start, but sometimes they need to end. So that's efficiency. Public respect, of course. These days the criminal justice system is really being challenged. Actually is not a bad thing, but I think the American democratic system kind of makes it our duty to challenge things when we think they're wrong, right? So the criminal justice system, there are a lot of things that aren't equitable, and aren't right, and so there are people that are questioning that. So the thing about that now puts the criminal justice system, um, it puts it under fire, right? So now people are losing respect for the criminal justice system, and it's one we have rules in the criminal justice system so we can kind of ensure that the criminal justice system is respected. Um, Fairness, and one thing that lends to lack of respect is if people aren't treated fairly. If people feel like they're not treated fairly or didn't get their shot in court, they're gonna always hold a grudge against the system or people in the system, because people are the system. So you don't get charged with the crime without a person being involved, either a law enforcement officer or a individual that goes to the magistrate and has charges filed. So people are imperfect, right? Because people are imperfect things happen, but we at least we want a person that's charged with the crime to have his or her day in court, and we want it to be as fair as possible. So even if they are convicted, a person things can be totally fair, and a person still be wrongly convicted because the criminal justice system is not perfect. When you have a jury trial, um you have 12 essentially imperfect people that are now being charged or with now having to make a decision of guilt or innocence, and none of them were there. As a matter of fact, if they are there, and that means they're witnesses, and they can't serve on a jury. So if you're a witness in the case or you know what happened, that disqualifies you from being a jury in that case. So that means we're bringing 12 people that don't know what happened, they weren't there, and they're having to make a decision based on what it looks like. So that's imperfect. So they can be a totally fair trial. All the rules were followed, but the people who were trying the case, or the people who were trying the facts or having the facts given to them and being argued and listen to arguments from both sides, got it wrong. They didn't get it. Sometimes they don't get it wrong because there's a racial bias or any type of cultural bias. Sometimes they get it wrong because they got it wrong, and it can happen. That's the fear of jury trials or bench trials, because even worse with bench trials, because and a bench trial is a trial where the judge is not a judge is the jury, so they're determining guilt or innocence, and they're determining matters of law and sentencing. The scary thing about bench trials is that a judge, at least in North Carolina, they are elected officials, and you can't be an elected official without being compromised a little bit. Matter of fact, I'm sugarcoating it. You can't be a judicial official without being compromised a lot of bit. There's not no such a word. Instead of a little bit, I said a lot of bit. Um, just the fact that you're an elected official, that means now you're on the ballot. You've promised people certain things, and you're on that ballot. And of course, that's a job. And it's a job you want to keep, because you can get fired as a judge. You know how you get fired? Someone runs against you, and the people say we don't like that person, and they vote you out. So now, just by virtue of being an elected official as a judge, you now want to do things to keep you there. And sometimes that means you might have to make a decision, based upon you wanting to stay in that seat. And it doesn't mean judges actually do this, but it is what it is, right? Well, we presume that they're fair and they're doing things for the right reason, but that's a rebuttable presumption. That means it's presumed, but it can be proven that it's not, that you're not a fair person. So just being an elected official and being on the bench and making decisions in trials, being an elected official by itself means that you're compromised. So if you were just appointed and didn't have anyone's interest that you promised to take care of, or anyone that helped you to get elected, or you don't have any group of people that you feel like you have an allegiance to, but if you don't have that, you normally don't have that if you're appointed or you have a lifelong appointment to a seat. That means you're doing what you think is right, and you're not worried about the consequences. You're doing stuff on a case by case basis. But if you're elected, you always have to make decisions based upon, hold on, is there going to be a newspaper article about what I did today? I think I did the right thing. I listened to the case, I listened to the facts, and this was right. But because the system is adversarial, you have two sides. That means usually at the end of every case, someone wins and someone loses. So someone's always mad, right? So that mad person can be mad and can complain and say this isn't fair. Um, so you never know. You may have the newspaper or the media in court, and they may be reporting on what a judge did or said or how they ruled on the case, not even knowing the facts of the case. And they put a newspaper article out, and now this judge is under fire for something they did that might have been right, might have been legally right, or might have been morally right, if not right by law. Because something we'll learn that sometimes legality and morality don't actually meet all the time. There's a difference. So you'll see some rules of law on the book that you're like, yo, that's just not moral. That's terrible. That's stupid. Doesn't make any sense. It's like that. Welcome to America. And we'll get into that. I'm also very woke, and I'll give you real discussion on sometimes the stupidity of the legal system in America. Um, because I love America. When you love somebody, that means you tell them when they're doing good and you give them constructive criticism. I think a lot of people think when you say something bad about America, you don't like America. Doesn't I think the people you love the most, you tell them when they're wrong, right? Because you want them to be correct and you want them to do better. That's how I feel about America. So sometimes I am critical of things that happen in America. Doesn't mean I don't like the country. Doesn't mean I'm not that I'm anti-patriotic. It just means that that's wrong and it should be changed. I think as an American citizen, I have that right. So sometimes I'll talk about the numbers in America and the thing, and whether America is really free or not. So we can't be that free because we have a lot of there are a lot of things you can't do walking around as an American. If you walk out of your house every day, and there's a 99.9% chance that you're probably going to violate some type of law. That means there are a lot of laws on the books. And how can you be the freest nation if there's a lot a person can't do, and there are a lot of hindrances to freedoms? So I'll bring that up there, and that's a question that may come up in a group discussion or in one of our discussion panels. So we'll talk about that. But so we got fairness, equality. Want to make sure everyone's being treated equal. We'll talk about that. Effective legal representation. We get in that. We talk about what the job of defense attorneys, what they're supposed to do, and popular participation, and that's when you're a jury. So we'll talk about the correlation between being a voter and a jury, and on a juror, being able to serve on a juror. Because in most jurisdictions, you can't be one without being the other. So you're not going to even qualify to be called to be a juror to make decisions in a court case as a juror unless you're a registered voter. So registering to vote is more than just about voting for the president and voting for the mayor. It can determine whether or not you're impaneled to sit and determine guilt or innocence for someone. Very important. So that's popular participation, and of course, then we have allowance for appeal. So we want to give if a person feels they were done wrong by the system, we want to give them an avenue in which to correct it or start the process for correcting it. So that's the appeals process. Now, the criminal justice process. A criminal felony case in the federal criminal justice system progresses through a number of stages. And that's that. I showed you guys that flow chart, or that I call it the machine. Those are the stages. Um, the first step is a criminal investigation. And sometimes the criminal investigation starts without there even being a person to put in the system. So something happens and someone's accused, there's a crime that's taking place. There's a dead body with a hole in it. So somebody put that hole there. So there's an investigation to figure out who shot that person. At that point, now there's an investigation to get down to the truth, to see what the evidence says. Then once they do that, hopefully that evidence will lead them to a person who did it, or who can be accused of doing it, based upon the weight of the evidence. So there's an investigation a lot of times before a person's even put in the system. So there are actually rules that govern the investigation. So before you can even be called out and become a defendant, there's an investigation that takes place before that in certain cases. So before a person's even in the system and charged, there's still rules that govern how law enforcement is supposed to act. So but the first step is the criminal investigation. The last step is a petition for what we call post conviction relief or an appeal. So it starts from the investigation all the way through appeals. That's the beginning of the machine. The end of the machine. I'm sorry, is the appeal process. This lengthy procedural process protects individuals against unjustified detention, arrest, prosecution, and conviction. All of which we'll talk about. The sources of criminal procedure. Where do we get criminal procedure law from? Um, the sources of criminal procedure include the U.S. Constitution. The U.S. Constitution is the supreme law of the land, and that is our major source of criminal procedural law. A lot of times we'll get constitutional amendments, but then sometimes the amendments may be a little ambiguous, and you have to have case law or judicial decisions that help us pinpoint what the Constitution means or how we're going to um, what I'm saying, how we're going to interpret it, what's going to be the rule of law about how it's interpreted. So that the U.S. Constitution, judicial decisions is how we interpret the law. That's what the judiciary does. So you have then you also have state constitutions. They also apply, but of course, no state constitution can ever hinder the power or undo any power or any constitutional promise of the United States federal constitution. So remember that. So the federal constitution is the supreme law of the land. Um, you have the common law tradition, and what that means is anytime we say common law, what we're talking about is old law. So we're talking about law passed down from Europe, essentially, and sometimes law can be older than that. You'd be surprised where law comes from. Certain law in America, all laws in America aren't even influenced by Europe. Some law in America is influenced by Native Americans that were actually here. Even the bicameral legislature and things of that nature. The way our government set up is maybe more influenced by the way Native Americans govern themselves, as opposed to how Europeans governed before they came over. You also have legislative statutes, and the legislature is an elected body of officials that make laws. So you got senators, you got congressmen on the federal level, you got state senators and congressmen on the state level, but they're the people who get together to decide what's going to be illegal and what's going to be legal and illegal. And they also make criminal procedure laws. So any law that's made, whether it's in the Constitution as the supreme law of the land or it's codified as some type of legislative made law, that law is always subject to interpretation by the judiciary. And of course, that starts back to really the civics thing of criminal procedure, where you have the judiciary branch, you have the executive branch. Well, let's start. You have the legislative branch, you have the executive branch, and you have the judicial branch. So of course, the legislative branch, their job is to make the law, to codify and write law. As a matter of fact, the Constitution actually is a legislative body of law because a group of men that were representing states got together and decided what amendments to put in the Constitution and all this stuff. So that actually is a legislative body of law. Then you have the judiciary, who looks at legislative bodies of law. They look at acts of the legislature and what they produce, and they determine whether it's constitutional, whether it's right or wrong, and what the interpretation of it should be. Because actually, most laws that are made by legislative bodies usually come off the page when we look at them on the black and white of a page. Usually, there's always something wrong, something missing, or it's ambiguous. So a lot of times, things have to happen that has to go to either the Supreme Court, or it has to go through the judiciary before we figure out what these ambiguous things are supposed to mean, and we answer these questions. So that's why the judiciary is so important. Sorry, mouth real full. The judiciary is so important. It's important because they interpret the laws that are made by the legislator. Then the third branch of government is, of course, the executive branch. The executive branch, presidential or even gubernatorial or governors, and that branch, the executor or the executive, they're charged with placing people in place to enforce the law. So actually, the president of the United States is a law enforcer. So there's this law on the books, and it's his job to kind of plan how the law is going to be forced, even on a budgetary level, to see, okay, the reason we have the environmental protection agencies is because we have environmental laws that are made by the legislature. Somebody has to enforce that. These standards of smog in the air and environmental standards. So you have cabinet level positions that are appointed by the president, so he can put people in place and they can start to enforce the law. So the president of the United States is actually actually set up based upon the three branches of government. He's the enforcer. So you have the legislature who makes the law, the judiciary who interprets it, and you have the executive branch who is the enforcer, or they plot out the plan for how it's going to be enforced. Um, that's the kind of the I guess sinking of all three uh, I guess parts of government. Then you have agency regulations, and you also have model codes. Model penal codes, or model um, criminal procedure codes that's usually when we have a merging of the academic sector, people who teach law, people who practice law, judges, and even some law enforcement that get together as a body to say this is what we feel like it should be. And they actually come out with a code of books, but it's a model code. That means it's not being a model is that means it's to be looked at. That means it either can or can't either it does not have to necessarily be adopted by jurisdiction. Most jurisdictions look at it and they like the model penal code or the model criminal procedure code, and they say, "Hey, we like that rule because the best of the best got together to make it. So let's adopt it and make it our rule." But that doesn't necessarily mean they have to. So it's just that it's a model code. It's something that's used and it can be used kind of as as an advisory tool. So the structure. Let's move on to the structure of the federal and state court systems. And I've kind of touched on at least the state court system with North Carolina, but we'll talk about the federal. The United States has a federal system of government in which the United States Constitution divides powers between the federal government and the 50 state governments. There are parallel judicial systems. So what that means is you have a federal judicial system that's parallel. Of course, it's on top. And under this federal judicial system, you have the state judicial system. So each state has its own judicial system and set of judicial laws. Um, there are the parallel federal courts address those issues that the U.S. Constitution reserves to the federal government. So we call them, in other words, federal issues or federal subject matter jurisdiction. We call it federal subject matter jurisdiction. Um, while state courts address issues that are reserved for the states. So most laws that we are governed by every day are state and local laws. The federal law is wider and it usually deals with interstate commerce and certain things. Some things are both illegal federally and on the state side, depends on what it is. Um, but for the most part, the laws that govern us on an everyday basis are normally state laws. Very seldom, unless you're trafficking dope or something like that, are you violating federal law. Most of the time, when you violate these laws every day. It's the regular laws that are made by your state government or your local what I call it, your local lawmaking body. That would be your city councilmen and your county commissioners that kind of create these what do we call it, municipal codes and stuff like that, or ordinances. So you can, that in North Carolina, in most jurisdictions, in most counties, in most cities, like in Greensboro, where I am now, it's illegal to actually drink beer in public. I mean, to actually have open alcohol or even alcohol in the cup. You're not in most jurisdictions. You can't consume alcohol in public. You have to be in a private bar or be in a home. So walking down, it's illegal to actually walk down the street with a Bud Light in your hand drinking. You'll get it. That's actually depending on where you are. Now, there's some cities that are cool with that. And the crazy thing about state and federal law is each state is different. They have their own thing they apply. So you go to a city or go to a state like Louisiana, where they have New Orleans, which is the capital of drinking alcohol in public. You walk around with the hand grenade drink or whatever. They let you do that there, right? But in North Carolina, that's a no. That's a no go. In North Carolina, you can't buy a prostitute. You can't. The prostitution is illegal. But you go out to Nevada, you go to Reno or Vegas, and they have houses that are literally made for buying sets. So it's crazy. So from jurisdiction to jurisdiction, you have different rules, and it's crazy. But that's how it is. So that's essentially how the corporation of America is designed. So America is a corporation. It's a corporation with 50 different corporations joining together to kind of have federal governance, but under that, each state reserves its right to make its own rules about certain things that are in the state. And then some of those individual states don't have to deal with each other at all. That's why something can be illegal. Like just think about Colorado. In Colorado, we know weed is legal now. You can buy it at dispensaries, but in a neighboring state like Nevada, it was crazy. In Nevada, you can buy sets but can't buy weed. Um, if you have weed in Colorado, you're straight. But if you once you drive it over the border, you're now you now have an illegal substance in the state next door. As a matter of fact, if you bring the weed from Colorado and are driving it into Nevada, you actually may be charged with trafficking of the weed, even if it's just a small amount, just because you're carrying it from this place to that place. So it's crazy how states can be side by side and still not work together. And but states have that option. Um, the federal judicial system is based on a pyramid. Of course, pyramids are wide at the bottom and they get thin as you get to the top. Um, at the lowest level are 94 district courts. Um, and you have different you have 94 districts and you have different district courts. You and then from districts you have the circuits. So circuits is when it gets a little thinner. So every district is in a circuit. So in North Carolina, we're in the Fourth Circuit. So anytime you have a federal case in North Carolina and it gets appealed, it goes to the Fourth Circuit Court of Appeals. Um, and North Carolina itself has three federal judiciary districts. You have the Eastern District, which is in Raleigh. You have the Middle District, which is in Greensboro, and they actually have a satellite courthouse in Winston-Salem. And then you have the Western District, which is in Charlotte. So each state has multiple district courts, federal district courts, but it's a pyramid. District levels wide, and it gets thinner. Then you have these courts of appeals. Then when you get to the top, you have the Supreme Court of the United States. So appeals, as a matter of right, may be taken to federal circuit courts of appeals, as I said before. The U.S. Supreme Court has the discretion to hear appeals as the court of last resort. It is the federal court of last. Anytime you hear me say court of last resort, a federal court of last resort, we're talking about Supreme Court. The state courts of last resort are the state Supreme Courts. But if it's a federal question or a question of some type of federal constitutional right that's been violated, what things that happen in states can be appealed to the U.S. Supreme Court. So that can happen. So U.S. Supreme Court still is the supreme, I guess, law interpreter of the land. So the Constitution is supreme law, and the U.S. Supreme Court is the supreme law interpreting body of the land. So sometimes they can they can hear state matters, and sometimes they hear state versus state matters when states have beefs or have issues about usually about land or something like that. Um, because each state is a corporation, and states can actually make contracts with each other. So it's funny, but the body that actually serves as the mediator that has to make a final decision in those battles is the U.S. Supreme Court or the federal court system. State courts also have an organized form of a pyramid. Prosecutions originate in courts of original jurisdiction. And usually we call those district courts, same as federal courts. Other states call them something else, but North Carolina is district court. And of course, if it's a felony, the court of original jurisdiction, once it's indicted, is going to be superior court. So you have district and superior court. Then you have appeals that are made to intermediate appellate courts. Appellate means appeal. Appellate courts. Then from there, you can appeal to the state Supreme Court. So it's a pyramid once again. State Supreme Court being at the top. Each state Supreme Court may grant a discretionary appeal. So that means they can appeal at their discretion. Either they choose to hear it or they don't choose to hear it. Same thing with the U.S. Supreme Court. Precedent. Courts follow stare decisis, and stare decisis simply means that we're going to follow what's already been done. Which means that once a court has established a legal principle, this rule constitutes a precedent or a rule of governance that will be followed by courts in future cases that involve the same legal issue or subject matter. So what that means is once a court says this is what it is, the court system through stare decisis is going to lean towards doing what happened in the earlier case. Now that doesn't mean the law can't be changed. It can be changed, but the court's going to lean towards the precedent or what's already been set. The rule of law, rule of governance has already been set by an earlier court decision. Now that court decision can be changed. Look at Plessy v. Ferguson, and then you get down to Brown v. Board of Education. So they can't. So precedent can be changed. It is harder, but it can be changed. But for the most part, courts want to have something to lean on because, like, we go back to that early part of the chapter, we'll talk about efficiency and consistency not being one of the things on there, but I'll add it: consistency. Courts are only consistent when they follow stare decisis and precedent. So you want to be able to go into court and kind of almost be able to what would I say, predict what's going to happen based upon what the court has done in prior cases. And that helps the court move fastly because it actually helps a client and a defense attorney make decisions because they know what's likely going to happen. So it helps cases move faster. Um, Judicial philosophy. Supreme Court justices and other appellate court judges at times may disagree in deciding a case. These disagreements in many cases are based on divisions in regard to federalism, meaning what role the federal government plays in state governance, the role of precedent, bright line rules or the need to have just rules that say what it is, the proper scope of government power, sometimes differing approaches to interpreting the Constitution, and the separation of powers and the value of achieving consensus. So there are many issues. So when you have these lawmaking body, not law, these law interpreting bodies, specifically on the appeals courts and the state and federal Supreme Courts, and you still have individuals making decisions, and they bring in their biases, they bring in whatever their philosophy is in making a decision. That's why voting for the president is so important because he appoints to the judiciary. He appoints federal judges and Supreme Court justices. So if he has things that he wants people that are gonna further his philosophy or that share his philosophy. So that's the important thing about being active in government and voting. Um, then we have law in action versus law in the books. Law in the books is what we call de jure, essentially by law. It's written and codified. Law in action is called de facto, or law by the fly. My bad. But it's called de facto, law by action, or law based upon what's happening. So we have de facto and we have de jure. There is a difference between law established in cases and in statutes and the enforcement of law. Sometimes the law may say certain things on its face or on the page, but it may be enforced or de facto differently. So it's crazy, but we'll talk more about the difference between de jure by law or written in law and de facto by fact. In other words, just the way it's enforced, and even though it says this, we do it this way, so you're gonna do it. And a lot of times, that's the problem when you look at law. There's a difference between the way a law is written and the way it's enforced. That's the importance of these rules of criminal procedure, because we don't want enforcement to now be in a situation where they're making the law. That's not their lane. When we have law enforcement officers kind of making and determining what the law is as they're enforcing the law, that leaves room for unfairness. We're giving them discretion, and it's going to be unfair because now that law enforcement officer can determine what's legal and illegal right there on the spot, and that also leaves room for bias. That's how you can get pulled over for being black as opposed to being pulled over for doing something actually illegal. So that's chapter one in a nutshell. Make sure you read through it, and study the concepts. Read through everything, and you'll learn a little bit. It's actually a fun chapter. It's the overview chapter. I hope that you have enjoyed the chapter one lesson for today. Please read through it. Like I said, once again, go to the website. I said it before: www.sagepub.com/LIPPMANCP. Now there are other books that say CP2 for the next edition, but your questions are coming from CP, the one just the first edition, the online source for the first edition. So use that. Go to each chapter. Go to chapter 1, study it, review it, and then do those questions. You'll be fine. Y'all be good. Aggie Pride.